Nuisance. A drug lord and his family reside in a small bungalow where they sell shabu and other prohibited drugs. When the police found the illegal trade, they immediately demolished the house because, according to them, it was a nuisance per se that should be abated. Can this demolition be sustained? Explain. Suggested answer. No, the demolition cannot be sustained. The house is not a nuisance per se or at law, as it is not an act, occupation, or structure which is a nuisance at all times and under any circumstances, regardless of location or surroundings. A nuisance per se is a nuisance in and of itself, without regard to circumstances. Tolentino, page 695. Nuisance. State with reason whether each of the following is a nuisance, and if so, give its classification, whether public or private. Article 694 of the Civil Code defines nuisance as any act, omission, establishment, business, condition or property, or anything else which injures or endangers the health or safety of others, or annoys or offends the senses or shocks, defies or disregards decency or morality, or obstructs or interferes with the free passage of any public highway or street, or any body of water, or hinders, or impairs the use of property. It is a public nuisance if it affects a community or neighborhood, or any considerable number of persons. It is a direct encroachment upon public rights or property which results injuriously to the public. It is a private nuisance if it affects only a person or small number of persons. It violates only private rights. A squatter's hut. If constructed on public streets or riverbeds, it is a public nuisance because it obstructs the free use by the public of said places. City of Manila versus Garcia, Gr. No. L26053, February 21, 1967. If constructed on private land, it is a private nuisance because it hinders or impairs the use of the property by the owner. A swimming pool. This is not a nuisance in the absence of any unusual condition or artificial feature other than the mere water. In Hidalgo Enterprises versus Ballendon, Gr. No. L. 3422, June 13, 1952, the Supreme Court ruled that a swimming pool is but a duplication of nature, thus could not be considered as a nuisance. A house of prostitution. Irrespective of its location and how its business is conducted, it is a nuisance since it defies, shocks, and disregards decency and morality. It is a public nuisance because of its injury to the public. A noisy or dangerous factory in a private land. If the noise injuriously affects the health and comfort of ordinary people in the vicinity to an unreasonable extent, it is a nuisance. It is a public nuisance because there is a tendency to annoy the public. Velasco versus Manila Electric Company, Gr. No. L. 18390, August 6, 1971. Uncollected garbage. It will become a nuisance if it substantially impairs the comfort and enjoyment of the adjacent occupants. The annoyance and the smell must be substantial as to interfere sensibly with the use and enjoyment by persons of ordinary sensibilities. It is a public nuisance because of its injury to the public.